the international law, examining the international law from a strictly technical point of view, we could conclude that there are no written law in the international law system. We can reach this conclusion considering that, technically speaking, there is not a legislative body recognized by all subjects to the international law system. It has the states. It's a problem that, if you remind, we talk about at the beginning of our lesson, when we make a confrontation between the international law system and the domestic legal system. Because we have in the domestic legal system, we have the executive body, we have the legislative body, and we have the judiciary body. The most important, according what we are talking about right now, is the legislative body. We have every democratic or so-called democratic state as a national assembly, or a body of representatives that is able to issue the law to rule in the state. Instead, in the international legal system, we don't have this type of assembly. We have several assemblies, but no one to whom all the members of the community of the state recognize the power to issue law or regulation that could be valid for everybody, and everybody are bounded to respect. This is we shouldn't forget that even other subject has been been involved in the progression of the international law system. The international law system is still mainly a law of the community of the state. I mean about other subjects involved, I make a step back when you're talking about the subject of the international law. If you remind, we talk about the state, but we talk also about other subjects, and like the international organization, like the individuals, because there are cases in which the single subject, the single citizen of the state, can be subject of the international law, can be touched directly by the international law. So we have in the international law system, we doesn't have a legislative body recognized by all the community of the state. And for this, we can conclude that there are could be no written laws in the international law legal system. Instead, there is a kind of written law source, even international law system. And it is represented by the treaties. The treaty is something that we have talked a lot in the past lessons. They are maybe mentioned a lot of time. Now it's time to go in and deep in the matter and understand what the treaties are. So, what are the treaty? The treaty consists in the meeting. It consists of the meeting of the wills of two or more states, aimed to regulating the relation between them. Basically, is a definition that is considered very similar to the contract. It's more or less the definition of the treaty is similar to what is in many legal systems, the definition of the contract according to the private law categories. This fact should not be a surprise considering that the contract is a source of law between two individuals or entities to regulate their business relations. The contract can be substitutive of the national legislation, derogating its content, and establish different rules about the subject that specifically accept them. This happens frequently in the civil law system. It's also happened in it's the one of the pillar of the common law system. If you consider that in the civil law we have legislation, and we have the contract, that is the agreement of two parties which derogate this legislation or give some add-on to the legislation, dealing matters that are not specifically regulated by the legislation, at least between the two parties signing the contract. Instead, in the common law, we have a very little legislation, very small legislation. A lot of rules are dictated by judicial precedent, but also by the contract. So in a situation when there is very few law, the contract assumes a very important role, because the parties try to regulate everything what is not regulated by the law with the agreement between them. Instead, there is a distinctive difference between the contract written or signed under the civil law and the contract signed under the common law. If you have the chance to see them, the contract written under and signed under the civil law are smaller. Instead, the contract signed under the common law are tomes with a lot of party, a lot of clauses, everything is detailed, just to supply and support the missing of the law. The contract in this system, the contract it can be suppletive of the national legislation, filling the gaps regarding the missing regulation. Of course, this function is confined to the subjects that are part of the contract, but is openly recognized by the judicial authority. And in this, in the international law system, the treaties have the same function of the contracts in the private law. There is no legislation. Of course, there is some unwritten legislation that we talked before, but they are not written law. There is another body of representative of the state that issue laws. So the party, and in this case, the states agree between themselves how to regulate their relation. And this is something that should not be surprised, because also regarding the judiciary power in the international law system, we frequently mention it as very similar to the arbitration court. So basically in the international law system, the court are a kind of arbitration, in which the state voluntarily accept the jurisdiction of this court and submit to their judgment, exactly like in arbitration in the private law between private civil law between two parties. The treaties always existed in the human history since the first two tribes of hunter and gatherer agreed to share and draw boundaries of the hunting ground during the Stone Age. It's not something absolutely not new. The treaties have been used to regulate the relation between the state in several forms, to make peace, to create alliance, to regulate trade and custom right. From the legal doctrine point of view, the treaties can be divided in two categories as a written source of international law: the codification agreements and the sources of particular laws. The codification agreements are, let's say, it's a tentative to create a legal system or a legal compartment that can be shared and accepted by a multitude of the states. The codification agreements are multilateral treaties with which the community of the states try to find a common ground to regulate certain relevant international matters that involved or could involve all the states. Basically, it's the production of the codification agreement tried to supply the lacking of the, let's say, a representative body with a legislative power. The codification agreement were born in the second part, between the second part and the end of the 19th century, when the community of the state did multiple tentatives to regulate the state of war between the two nations. The community of the state tried creating an international war legislation through multilateral, several multilateral treaties. This is not something that so the first matter that the community of the state tried to regulate or to give principle or common ground to regulate was the matter of the war. This is nothing that should be surprised, because it was the second half of the 19th century was an age of changes, an age in which there was an improvement of technology in all the fields, and even in the military field. This development caused the wars to become very bloody affairs. And you think about, you are not familiar with that, but one of the bloodiest conflict of this time was the American Civil War. The American Civil War, from some historians, is considered the first modern war, because it lasted for several years, something that, aside from the Napoleonic War, was not seen from centuries. There were millions of soldiers deployed on field, and there was a lot of new technology that were applied. For example, the machine guns, the mines, the trench fortification, repeating rifles, and the balloon from observation, even the submarines. The first, and that was why the humankind started to think that it was better to regulate this type of historical event, at least for what is possible. The first type of this tentative of codification agreement of this type of multilateral treaties were the Geneva and the Hague Convention, produced by the homonymous international conventions. This convention, as a treaties, are two distant package of treaties that time to time interact between themselves, touching the same matter and updating each other. The first Geneva Convention was organized by the Swiss government on a proposal of one of its citizens, Harry Durant. Harry Durant is a very prominent figure in history because it's one of the co-founders of the International Red Cross. And he have this idea of the Red Cross after visiting the battlefield of the Italian Second War of Independence, the war that saw Italy and France against Austria to liberate part of the Italian territory. He was so shocked to see the result of the battle, the hundreds and thousands of wounded lying on the ground, that he started to think about an international organization that could assist the wounded and the sick during the war. The first Hague Convention was organized by an impulse of the Russian Tsar Nicholas II in 1899. The Hague Convention was organized by the impulse of the President of the United States, Theodore Roosevelt, in 1907. The package of treaties known under the Geneva Convention is composed by 4 treaties and 3 amendments protocols. The first Geneva Convention was organized in 1864. So the first, the Hague Convention was in 1899, the second 1907. So we see that everything was done in a time frame of around 25, 35 years. So we say the Geneva Convention is a package of 4 treaties and 3 amendment protocols. The first Geneva Convention, considering Geneva Convention as a treaty, regards the condition of the wounded and the sick of the armed force during the conflict on land. And it was adopted in 1864 and reviewed 3 more times in 1906, 1929, and 1949. The second Geneva Convention, still as a treaty, regards the condition of the wounded, the sick, and the shipwrecked of the armed force during the conflict at sea. And it was adopted in 1949, and it was ideally the successor of the Hague Convention number 10 of 1907. So we have the first one about on the land. Second the convention regards the war on the sea. This was not, it was a matter that was not dealt with during the first Geneva Convention, and it was taken consideration by the second the Hague Convention in 1907. Some historical reason for that, and we talk it about in few minutes. The third Geneva Convention instead regards the treatment of the prisoner of the war. It was adopted in 1929 and revised in 1949. As you see, all the Geneva Convention were revisited after the Second World War. That was naturally because, as we see, there were certain rules that were put up by these multilateral treaties that were basically disattended or not enforced during the First and the Second World War. What was left after the First World War was disattended during the Second, where the brutality of war was an extreme matters. So in 1949, there was a necessity to reestablish the rules. Instead, the fourth Geneva Convention regarded the treatment of the civilian during the time of war. It was adopted in 1949, so was not considered at the beginning of this period of codification of multilateral treaties. And is roughly based on parts of the Convention of 1999 and the Hague Convention 4 of 1907. Unfortunately, we have to notice that at the beginning there were some only some aspect of the law of war was regulated by the convention. This also because there was still, in some way, it was the idea of that the war should be people in war should they act like gentlemen. It was not in or in a chivalristic way. Of course, it was not in this way to the most part of history. We have seen other episode of in which the brutality was rampant. But let's say that with the beginning of the 20th century, all the let's say all the old agreement, old style was cancelled, and the brutality became something during the wartime became something extremely common, if not the rules. The protest, we say we have for the Geneva Convention, we have 4 conventions. It has treaties and 3 protocols. The 3 protocols has been issued in 1949, and they were amended even during the recent time. The first protocol regards the protection of the victims of the international conflict, and it was approved in 1977. The second protocol regards the protection of the victims non-international armed conflict, and it was still approved in 1977. Difference. One speaks about victim of war. The second speaks about victim of a civil war, not international conflict, internal conflict. We are at the beginning of this of that process that produced the international crime court that was created in after the 2000. The third protocol regards, it was something very basic, the adoption of the red crystal as an alternative emblem for the Red Cross or Red Crescent, and it was to approved in 2005. This probably is the less important. It is a kind of politically correct protocol, because the Red Cross was always been symbolized and represented by religious symbols. The Red Crescent, the Red Cross, the Red David Star. There was the idea that something more neutral can be used as an alternative. The fourth convention of Geneva has been adopted as a whole, and or with some reserves by 196 countries, while the protocol has been adopted by a less number. The most notable exception regarding the countries that didn't approve the protocols are United States, Turkey, Iran, Pakistan, India, Myanmar, and Mexico. Let's say that the Geneva Convention right now are approved by and are being by let's say the majority of the states. And it was a huge step further, because that during the Second World War, there were countries that, important countries, that they don't recognize the Geneva Convention. One was Japan, and this country treated the prisoner of war with an incredible brutality, and also the civil population of the occupied countries were also treated with an intense brutality. And when we think about the Second World War, we always think about the Nazi regime, the Nazi occupation in Europe. But what the Japanese did in the Far East, this is not for ideology, but maybe more for a specific ethic and philosophy. Japan was a militaristic country, was a militarized country. That was something that probably should have ashamed even Himmler SS. And so it was something, the adoption was still very important. Regarding the protocols are the key, the subject of the protocol are the civilian. And the reason why they are not being adopted by this country are different. The US, because tradition to want to have free hands when they move in abroad when you are in a state or in a situation of war. If you think, if you remind, the United States refused also the jurisdiction of the International Crime Court. So this is Turkey, Iran, Pakistan, India, because they have their own philosophy. Myanmar is a country that has been plagued by internal civil war for, I think, the last 60 years, and there is still a war right now. The second multilateral group of multilateral package of multilateral treaties about the world, they were produced during the Hague Convention. The first Hague Convention was opened in 1899. The Hague Convention package of treaties consisted initially of 3 treaties and 3 declarations. The treaties approved were the first convention for the Pacific settlement of international disputes, which included the creation of a permanent arbitration court to resolve the dispute between the states without recurring to the use of force. This arbitration court still exists today and is still today's function. This is a very, I think, is a pivotal convention because it's the first tentative to avoid the starting of the opening of hostility and the declaration of the state of war between two countries. The second convention is about the law and the custom of war on land, which included the principle established by the Geneva Convention of 1864 regarding the sick and the wounded. So the Geneva Convention was the same principle were taken and enforced by the Hague Convention. This convention also includes the first rules regarding the treatment of the prisoner of war, the prohibition of the use of poisons, the killing of the surrenders, the looting of the occupied areas, the attack or the bombardment of undefended location, the collective punishment of the inhabitants of the occupied areas, and their forced enlistment against their own country. These are very important principles, and if you see, there are some very important themes, so still debated today in the matter of the ethic that should be applied during the military operations. It's one important additional important element is aside the treatment of the prisoner of war, even the killing of the surrender, because it's something that should not be done, but until the first Hague Convention, there were no rules about that. So technically, if someone, a fire squad, killed a surrendering prisoner, the officer who did it cannot be persecuted at the end of the war. The third convention was for the adaptation to marine warfare of the principle of the Geneva Convention of 22 August 1964. So the extension of the rules already established for the war on land to the sea, to the war on sea. This convention includes the institution of the hospital ship and the obligation to assist the shipwrecked or the wounded sailor. Something not before. It was no obligation to help the survivor of an enemy ship that was sunk. Plus, there were I think it was, I'm taking some a lot of attention of this matter, because I think that can be something touching for many of you, but I think is something that to make you realize where we are coming from, and unfortunately the point that we still are, because these matters are still debated today, and something that you can find even in the newspapers or on the TV news, and that's very sad. The declaration were three. First declaration was concerning the prohibition of the discharge of projectiles and explosives from the balloon or by other new analogous methods. So it was a declaration against the air bombing. That's something that was huge. Second declaration was concerning the prohibition of the use of projectiles with the sole object to spread asphyxiant poisonous gases. This is something that so far until now was not something that not happened for the last almost 90 years, but was something that was heavily implemented during the First World War by the Central Powers, and the intent by both the parties. The third declaration was declaration concerning the prohibition of use of bullets which can easily expand in charge their form inside the human body, such as bullets with hard covering, which is not completely cover the core or containing indentations. Basically, it's against the explosive. This is also the limit, the suffering of the people that were involved in war, forbidding the use of the explosive bullets, the dum-dum, that are the projectiles that open up and create larger wounds, or for the blade weapon to use the dented blades that create even more damage when they are extracted. The convention were approved and adopted by all the major powers of the time, as well as the declaration. The only notable exception were the United Kingdom, which refused to ratify the first declaration. That was the declaration regarding the use, the throwing of explosive and projectiles from the balloon or from the air machine, and the United States, which refused to ratify all the three declarations. As we say, what we have faced until now in the international, regarding the international legislation about the law of war, or the laws applied in the war condition, let's say the reluctance of the United States to approve this type of law is not a diplomatic tendency that was let's say implemented mostly by the last government. We can say that there was a tendency of the United States policy, diplomatic policy, for almost more than 100 years, since the United States started to be a big player in the international world scheme. The Hague Convention was the Hague Convention of 1899 was followed by a second convention in 1907. This time, the convention was colored by the President Theodore Roosevelt. Roosevelt was a very unique individual. Was really something personally incredible. You think that he was, let's say, one of the probably the president that established the international, the importance of the international role of the United States. He was already in the establishment of the government in 1898. He was Secretary of Navy. In some way, with the agreement with the president, creating an accident that started the United States Spanish War, that brought to the canceled the last part of the Spanish colonial empire, so such as freeing Cuba, Puerto Rico, the Philippines. He established this predominance, and he take part personally to the war, something totally unusual for a politician. Even this way, he resigned from his position as Secretary of Defense, and he became the commanding colonel of a troop deployed on field. And he actually lead his troop in a charge during a famous battle. So he was a kind of very peculiar character. He was also, as you say, he understood for first that would be the role of the United States in the future international set, and he understood also the importance of the naval matter for the United States. In fact, he not only colored the convention, but we will see the convention will be more focused on the naval war. The treaties of the second convention were expanded to 13. And some are an update, some are totally new, some are a mix of matters previously touched by other treaties. Plus, in addition to these 13 treaties, there was a declaration. The first convention is still for the Pacific settlement of the international dispute. And the convention expanded the contents of the 1899 convention. This convention is still enforced by 102 countries, plus half a dozen states, for which it was ratified by the legal predecessor states, but not yet ratified by the successor state. What I mean, it was signed by the kingdom and ratified by the Kingdom of Italy, and it was not the Kingdom of Greece, the King of Ethiopia, the Kingdom of Iran, but it was not later ratified by the Republic of Italy, the Republic of Greece, the Republic of Ethiopia, and so on. So this technically also these countries, successor states, are bounded, but they're not ratified yet. In regard to Ukraine, the convention was signed in 1962 by the Ukrainian SSR. So the SSR, Ukrainian SSR, as a part of the Soviet Union, signed this convention, and technically it is bounded. I can think that the current Republic of Ukraine has also ratified the convention. The second convention concerns the respecting of the limitation of the employment of force for recovery of contract debts, which allows the use of the force for debt collection among the states only after refusal of an arbitration to settle the matter. This was something kind of typical of the international politics of the time. They were some countries contracted debts in various forms towards other countries, and there was a kind of common practice to enforce the payment of this debt using the force, declaring war, winning a war, to cancel the debt or to collect the debt. One famous case is the conquest of Algeria by France. France was extremely indebted with Algeria, because Algeria during the Napoleonic War supplied grain and other cereals to food supplies to France. France never paid. The successor government refused always to pay. The Algerian Bey pushed for this payment. At a certain point, the French government took this request of payment as a casus belli to occupy Algeria and transform it to the French colony. The third convention instead, it's relative to the opening of the hostility, and this convention disciplines the procedure to declare war. A famous breaching of this convention was a bombardment of Pearl Harbor by the Japanese aviation in 1941, causing the joining of the United States in the Second World War. Technically speaking, there was no war declaration, and it was a predatory attack perpetrated without a proper declaration. There was an interesting story about that. The Japanese in 1941 doesn't want to breach this convention. They try to do their best for respect it by keeping the advantage. So the idea was that the Japanese diplomats in Washington has to give to the Secretary of Defense the declaration of war, let's say 1 hour before the attack. So basically, the situation was we declare war, immediately we attack. The problem was that there was a misunderstanding regarding the time zone between the diplomatic mission, a Japanese diplomatic mission in Washington, and the Japanese military headquarters. And because of this misunderstanding, the declaration of war arrived immediately after the attack. And this made the American absolutely mad. The first convention is about the respect of the law and custom of war on land. And this is a more or less a confirmation with some little extension of a previous convention with the same object signed and approved in 1899. It was this, there was this, so the timeline is the Geneva Convention, first the Hague Convention, second Hague Convention. More or less the same matter. Fifth Convention, relative the right and the duties of the neutral power and person in case of war of land. This is a convention that guarantees the neutrality of people, states, and private property caught in the middle of the war. Sixth Convention, relative to the legal position of the enemy merchant ship at the start of the hostilities. This is something another. If you see, this is where we see the hand of the President Teddy Roosevelt. Teddy Roosevelt was very focused on the situation of the sea. He believed strongly in the predominance of the United States in the future on as a major power, and everything passed through the naval power. So a lot of rules are dictated in the convention that they called around the matter of the war at sea. Eighth Convention was relative to the line of automatic submarine contact mines, another aspect of the sea warfare, the mines. Ninth Convention is the naval war, the bombarding of cities, ports along the coast. 10th Convention for the adaptation to marine warfare of the principle of the Geneva Convention of 6 July 1906. That is more or less an update of the previous convention with the same object, signed in 1899, according to the update of the Geneva Convention of 1906. So basically, we have the first Hague Convention that extended the Geneva Convention from the war to the land to the war to the sea. There was an update of the Geneva Convention in 1906, and again there was the Hague Convention in 1907. Convention number 9, relative to certain restrictions with regard of the exercise of the right of capture in the naval war. Basically, this is connected with the privacy and the possibility to, let's say, do some regulated piracy against the enemy ships during the time of war. Convention 12, relative to the establishment of an international prize court, which was signed. This was signed and ratified only by Nicaragua. It was funny, see, because when you capture in the previous convention, dictated the rules according which an enemy merchant ship or civilian ship can be captured. This was episode that already happened in several wars. What he was trying to do, he was trying to create a court to establish the value. We can judge the value of this captured ship and eventually establish a ransom to be freed. This was completely a fiasco because no country was, except Nicaragua, was willing to accepted this type of regulation. Third convention regarding the rights and the duties of the neutral powers in the naval war. So we see everything was a lot of focus on the naval warfare. In addition to the 13th convention, multilateral treaties, at the Hague Convention of 1907, there was only one declaration. The declaration prohibiting the discharge of projectile and explosive from balloons and other flying objects, which was, this convention was an upgrade and an extension of a previous declaration with the same object. In 1907, this declaration was signed and ratified only by United States, okay, interesting case, among the other moderate powers. Because why? Because every major power recognized that there was the beginning of a new era of warfare, with an extensive. No one has a clear idea how the flying machine could be developed as a weapon, but everybody recognized it. The balloon was already used for observation in several wars, starting from the Civil War, the American Civil War. In 4 years, in 1911, during the Italian-Turkish War, the Italians were the first to use the planes for reconnaissance. And then there was a crescendo, because in a few years during the First World War, there will be the bombing of London with the Zeppelin, that they were the flying ships, and later by the bombers. Many of the rules of the Hague Convention and Declaration included the rules for declaring war. The use of the poisonous gas, the dropping of the bomb from the air vehicles were violated a few years later by both sides during the First World War, and the others, the surviving others, during the following wars and the World War II. But the legal principle established by the Convention for Laws and Custom of War on Land were recognized on principles agreed by all the civilized nations by the judgments of the Nuremberg trial. So, basically what's happened? Everything was agreed on the Hague, was disattended during the following 40 years. But some principles, and there were principles that were used for the Nuremberg trial, because there was the first case in which there was the recognition of the war crimes. There was, if you remember, there was a request of to put on trial for war crimes of the Kaiser after the end of the First War, but it was never really pushed. At the end of the Second World War, there were the Nuremberg trial, there was the Tokyo trial, and to find a legal ground on which the sentence should be based, the Hague Convention was used. The principle of the Hague Convention were used. In the same way, the Convention 1 on the Pacific settlement of the international dispute is still considered valid and ratified even recently by all the newborn states or state-like entities which want to become state, such as Kosovo and Palestine. So even if still the principles are alive and considered, because two entities which we say we are not technically state, Palestine and Kosovo, ratified the Hague Convention. It's interesting because in both cases, the ratification to the convention, one, was presented by Netherlands. Holland was the advocate of this request, presented it for both the Palestinian Authority and the Kosovo temporary administration. After these initial attempts focusing on the war legislation, the codification agreement properly started with the birth of the United Nations. And this has sense because you think the Geneva Convention were formed in 1941. In 1941, after the Second World War, there was a big change in the world policy. The idea behind to create an organization able to represent the community of states, pursuing the common benefit, banning the use of force in international relations, is closely connected with the idea of a coded international legislation. The idea of international legislation produced by the United Nations is expressed by the Article 13 of the United Nations Charter. This article assigns the General Assembly the task of adopting recommendations that encourage the development of international law and international codification. So what happened? There was a reform of what already existed. There is the idea to create an international assembly that could not become a legislative body, but could push to create a common ground for an international written legislation. Since there were no authority with legislative power in the international community, the treaty choice was the only tool to transform unwritten law to written law. To achieve the object posed by the Article 13, the Assembly established a dedicated body, the United Nations International Law Commission. What are the tasks of this commission? Its tasks are to proceed with the arrangement of customary regulatory text, preparing multilateral convention open to ratification by states, convening international conference of states for drafting or draft agreement, or establishing international committees to pursue this objective. So it's this entity as a task to push, to try to create an international legislation. By creating new law through multilateral convention, but also to create text of customary agreement based on the customary regulation, to transform the customary regulation that we have seen as an unwritten source of law in a written source of law. Until now, the Commission has codified the rules operating in almost all areas of international law. The Convention has produced 13 conventions so far. Convention of the Laws at Sea, signed in Geneva, approved in Geneva in 1958. Convention on the Diplomatic Relation, signed and approved in Vienna, 1961. Convention of the Reduction of the Statelessness, signed and approved in New York in 1961. Convention of the Consular Relation, Vienna again, 1963. Convention on the Law Treaties, Vienna, 1969. Convention on Special Mission, New York, 1969. Convention on the Prevention and the Punishment of Crime against Internationally Protected Persons, including the diplomatic agents. Again, New York, 1973. Convention of the Representation of the State in their relation with the international organization of an universal character, Vienna, 1975. Convention of the States Succession in Treaties, Vienna, 1978. Convention of the Succession of State in Public Asset, Archives, and Public Debts, 1983. Convention of the Law Treaties between state and international organization or between international organizations, Vienna, 1986. Convention of the on the law of the use of the water courses other than the navigation, New York, 1997. Convention of the jurisdictional immunity of state and their property, New York, December 2004. In addition to the United Nations International Commission, also the General Assembly in the past has organized some international conference with the purpose to proceed with to produce codification agreements. Then we have to, what we have to think about after this list of codification agreements. We have to think what are the legal value of this agreement. Although the codification agreements contains and are based on the customary law, they cannot also apply to not ratifying states. It not bound a state that not ratified the agreement. Binding only the contracting parties, they can be qualified as normal treaties according the categories of the international law. As we say, the treaties bound only the signatory parties that decide how to regulate their relation. Therefore, we must be very cautious in considering codification agreement as a corresponding of a general customary law. There was a tentative to transport through the codification agreement the customary law transform it into a written law. But while the customary agreement is bounding for everybody who accept it, everybody who follow its procedure, therefore a procedure or a way of acting is different from what is supposed to be done according the customary law, is considered a breaching of the customary law. In the codification agreement, the only states that are bounded are the states who ratified them. In addition, the binding value limited to the contracting party, there are in addition to the binding value limited to the contracting party, there are other reasons why the codification agreement do not correspond to the customary law. The reconstruction of the unwritten international norms is influenced by the belief of the interpreter, who could therefore modify the original meaning. What means that? It means that I have a customary law that is an unwritten law. I try to include it in a codification agreement to transform it in a written law. I'm decided to do that, and I will influence this transition with my personal opinion, a way to interpret the customary law. Second reason, the codification process is carried out at conference between states, which will naturally try to make their belief and their interest prevail over those of the other states, ending up influencing the definitive text drawn up by the United Nations General Assembly. So we have another influencing factor. Not only the writer, the material author of the text, but also the situation in which then they will be ratified. Because there will be diversity between the customary law and their transposition due to the fact that when there is the time to approve the codification agreement, the state try to force the situation in their advantage. Last reason is the text of the Article 13 of the United Nations Charter that speaks of a progressive development of international law. This concept has been used several times to include some norms in the codification whose existence was quite uncertain in terms of written source of general international law. Basically, in the process of transformation from unwritten law as a customary law to a written law with the codification agreement, there is already a process of changing that is trying to see an adaptation of this customary law. Actually, it's not something wrong, because as you remember, even the customary law is developed, is changed. We have speak about last lesson about the bound, the line between breaching of a customary law and changing a customary law. Because a customary law cannot be any more suitable for the different political situation from the general political situation. And there was a doubt, what is a breaching? What is a change? In general, all codification agreements are stipulated for an unlimited duration, but for some of them, a revision procedure is foreseen in view to create a new and more current agreement. So this is connected to what we say, what is written in the Article 13. A progressive development of the international law. So already the codification agreement foreseen this thinking, establishing that the rules are for an unlimited time. We will see, for example, for the normal treaty, something different, because usually some treaties, majority of the treaty has a time frame, and after a certain time they expire, and they have to be renewed and so on. These, the general codification agreements, are technically unlimited, but for some of them we already have the possibility of revision procedure. The update of the codification agreement can be necessary due to an update of the praxis in the relation between the states. And here again, we have the same point before. What is an update of the praxis? What is a change of the praxis, and what is a breaching? The possibility of an update of the codification agreement is further limited in their binding value to the contracting parties. If I have an update already of the convention, and this is an additional limited to be considered binding by others that not ratify and not approved this treaty. Okay, due to the fact that today I am a difficult logistical situation, for today I will stop the lesson here with the legal value of the codification agreement. And I will continue next time with other part regarding the the codification by the tentative of by the United Nations. Hello?
Okay.
Okay, so it's everything for today. I thank you for your attention, and we'll see each other in let's say 2 weeks from now.
Thank you very much.
Have a nice
Thank you so much. Yeah.
Have a nice day. Bye.
Bye-bye.
Bye. Bye.
Goodbye.